Så med detta sagt vill jag önska nästa talare upp på scen. Hon heter Karen Lawrence Öqvist. Hon är expert på integritetsfrågor och GDPR och hennes föredrag heter Embracing GDPR, Tools and Techniques that make compliance work across your organization. Så välkommen Karen. Welcome.
Hello? Det funkar. Okay, is there anybody here that does not understand English? Jag kan svenska, men det går mycket bättre engelska för mig. So I am CEO of Privasee, and it's a niche company that basically was established almost 2 years ago. And we are looking specifically at GDPR questions and compliance. Is there anybody in the room that doesn't know or hasn't come across GDPR yet? No, I think it's appeared on our horizon for everyone. I'm going to talk a little bit specifically about the cloud, GDPR compliance in the cloud, and a little bit of the background. Hang on, how does this work? Is it switched on? Oh, it's the other one. Okay. Good. Right now, basically, data protection is nothing new. And the GDPR is not something that was written on a clean sheet of paper. There's still a lot of hype around concerning, everything's changing, that it's something new, and it's not. We have PUL today in Sweden, and PUL is actually based upon the Data Protection Directive that was actually created in 1995. And the directive, just as all data protection laws and regulations globally, are based upon 8 basic founding principles. And even the US, this has even come from the US, which is called Fair Information Privacy Practices. So data protection is not new. However, what has changed and what has triggered GDPR, as we know it today, this upgrade, has been, I'm making it very easy here, but 2 contextual triggers. One of them is legal, and that is, it comes back from human rights. It's based upon the Data Protection Directive that we know of today and of PUL, so it's nothing new. And the fact is that everything that we do, what we're lacking at the moment is teeth. PUL doesn't have teeth, just as every data protection act in the EU doesn't have the teeth that the GDPR will have. So it means that there will actually be fines. Now, what is, can we say, forced an upgrade in GDPR is the digitization of data. So this has been moved from the filing cabinets of 20 years ago into a digital format. In fact, it's more than that. I wrote a book it was published in 2009, and I used to talk about our digital shadow. Once everything is digitized and what we leave behind us, whether this is in the cloud, online, or whether it's our telephone, whatever we do, is basically has a persistence value when it's in a digital format. And this persistence value could be duplicated over thousands of different storage spaces around the world. But where we are now is we're not talking about a digital shadow anymore. With the Internet of Things, intelligent homes, and the extension of our personal devices, which has become an extension of ourselves, our digital shadow has become us. And this is why the GDPR has happened. Because whatever we do, we are a walking, talking information creator. And this digital data is being stored somewhere. And the GDPR, along with other regulations that's been upgraded, like what you may have heard of the cookie directive, the e-privacy directive that's now become the regulation or will become the regulation, is about treating these devices as an extension of your person. And it's all included under data protection laws for the EU. Now, to really understand what this means, I think we should just have a look at what is personal data. It is anything, any data that can be linked to you as a living person, as a natural person, as it's called in the GDPR. When I have my legal lady there that will put me right when I make a mistake. And it says natural person because we have no rights to privacy in the GDPR before you are born or after you're dead. So don't die right now, because you lose your rights. So basically, this could be your cat or the GPS in your car. The GPS is in your car, attached to your car, but you own your car. The app on your telephone, because you own that telephone, and that app is using maybe two services, is using GPS and location-based services, and both are stored in different places. One of them is stored by the telecommunications provider, and the other, of course, is stored wherever the app is storing their personal data, their location data. You know, if you want to find where is my favorite coffee shop, they will have their own service somewhere where this personal data is being stored. Now, here in Sweden, we have additional challenges because we have something called missbruksregler, the Misuse Act, if you want to translate it literally into English. And so what it means is that all unstructured data under Swedish law, PUL, is exempt from the Swedish Data Protection Act. In the GDPR, this will no longer be the case. Sweden's GDPR, just as England, Germany, they will all be the same. Previously, how it worked, or how it works now, is the directive was guidelines in '95 on how each individual country in the EU should implement their Data Protection Act. With the GDPR, it is a law at the EU level that will be implemented by every single country in the same way, which means the Swedish Misuse Act, or missbruksregler, will be shelved, and we need to do something about all that data that is stored in emails and Word documents and Excel files or downloaded onto a USB stick that is not structured. The other thing that's a big difference here in Sweden, actually, if we're on the Swedish thing now, just to get this out of the way, is there is actually like a clash between the Data Protection Act, PUL today, and the offentlighetsprincipen, the Freedom of Information or Freedom of Press Act, or Freedom of Speech Act, I think Dana likes to use. And what this means is that our personal data in Sweden is public data. So if you want to send me some flowers, you can search for my name on birthdays.se, and you will find there the first 6 digits of my personal ID there, because that's how our personal ID is organized here in Sweden. Not the last 4 digits. If you want to know the last 4 digits, you can just ring up Skatteverket. And they are very kind. They'll tell you the last 4 digits because by law here in Sweden, my personal ID is public information. With the GDPR, if any of you are offering these services, this will no longer be the case. So if you are using a personal ID in your service, it will no longer, you need to rethink how you're going to do that. Right, now, basically, like I was saying before, the GDPR is actually, if you were to say, okay, where does it come from? What is the lowest common denominator in privacy? How do I get this for people in my organization to understand that do not have an LLM, a legal degree, like Dina over there. Is there anyone else in the room that's got a legal degree? Ah, 2 ladies. You got some company. So, what I normally do when I'm coming into an organization, I actually start with the OECD privacy principles, which were derived originally from FIPS in the US in '73, Fair Information Privacy Principles. Now, these principles are the lowest common denominator for privacy globally, because if that country has a data protection law, it will actually have started from here. So if you are offering a global service, and you find that the legal team in the EU is having an argument with the legal team in Australia, or the US, or some other country that may not have the same level of protections as we have, you can actually say, let's start at these principles and work our way up until we get to somewhere. Also, what I find with these principles is that it is a really good way to get a common language across the organization that is a little bit less legal speak. It's a little bit easier to understand than actually taking the GDPR principles per se, actually within the GDPR. So this is where I start. Collection limitation principle. Collect only what is needed for the purpose. And if necessary, get consent. You don't always need consent. You may collect personal data by using a contract. There may be a law that means that you need to do this. But anyway, collection limitation is collect personal data that is only absolutely necessary. Data quality is not security. Data quality is about the data subject. The data subject. Does everybody know what a data subject is? Yes. Data subject is us, you and me, individuals. The data subjects, as data subjects, we sometimes move house. We change name. Things happen. Data quality is about that. It's about our personal data being kept up to date in the simplest form of it. Purpose specification principle. There must be a specific purpose for the collection of personal data. If there is no purpose, you shouldn't be collecting it. So how I see that, for example, is the purpose I use that for scoping of my risk assessments projects. It's a good scoping tool. What's the purpose? And you keep within the purpose. Because when I do a privacy impact assessment, I do it by data asset. HR data is that you collect when you recruit someone is an example of a data asset. And an example, if you say, of collection limitation principle would be on a website. You may have a form on there, blanket, and you can restrict the collection of data by using this very simple mechanism, but that's just one of many. Use limitation principle. Internally, within your organization, use of personal data must be aligned to purpose. So, for example, if a customer is buying, or if you are buying a book on Amazon.com, and the purpose is for collecting your name and address is so that they can deliver your book to your home address. That personal data cannot be used by marketing. No. Unless it's actually part of the purpose, which I wouldn't advise. I would put that as a separate purpose and a separate risk assessment. The marketing guys will have to actually go through the process of doing it separately. So we've got the purpose for the collection of personal data to deliver your book, and that gets sent through to the department to deliver your book. But they don't need to know anything about what else you've been doing online. Security safeguards principle is information security, and it's to do with doing all of the security stuff in the other 7 principles. Openness principle, you need to be transparent, both in how you are collecting and processing personal data, and processing is anything you do with personal data. Anything. So, if you have a nearline storage, and you put personal data there, you are processing. If you back up that personal data onto a backup tape, as long as it is in storage, you are processing. Even if you don't do anything more, you are processing. If you zip it up and encrypt it, whatever you do with it, and put it into archives, as long as it's there, that personal data is being processed. And that is the use limitation. And openness and that's what needs to be defined in the openness principle on the privacy notice. Not all that detailed, but it's basically what you're doing in processing with collection and processing of personal data. Now, an example that we would all know is the privacy notice, which the controller has to have on their website. That should say individual participation principle. I thought I'd change that. And that is pertaining to the rights of the data subject. Now, the GDPR has been basically upgraded, and there is an enormous section in there about the rights of the data subject. And if you were to read through the lines of the GDPR, like I have done, it's basically saying that you own your personal data. You have a right to request if a controller is collecting your personal data, what they're doing with personal data to remove my personal data. Accountability principle is that you need to have the evidence in place that you are doing all of the other 7 principles. Now, this is what I use for common language across an organization, whether it's a national organization or global, particularly global. There is actually an ISO standard for privacy. Nobody really seems to be talking about it. You will find it actually sort of coupled up together with the ISO 27002 control framework in ISO 27018. And you will recognize some characteristics. So what it's done, it's like I said, those OECD privacy principles are the lowest common denominator. It's taken those and broken out some of the aspects so that us from a more, can we say we want to have a tick box approach? You can't tick box privacy, but I have tried to do that as much as possible. They have taken consent and choice. Let's see if this works. Consent and choice removed from collection limitation, so it's more specific. They have taken data minimization and removed that out from the use limitation. And they've removed out the privacy compliance out from there as separate, because sometimes you need to have separate privacy compliance when it comes to other laws and regulations. For example, I have a client who is basically, we are driven to be compliant with 2 regulations. We have the GDPR that we're working on, and we work with that together with the clinical trials regulation because it's for the pharmaceuticals. Now, what I thought I'd do in order to bring this into the context of cloud is I've taken this ISO standard to look at what was actually relevant if you are a processor. Because what I've been talking about up to now has been the controller. And the controllers are your clients. So I've put there what is really important is in fact for you got data minimization, and I was thinking about this. Where is data minimization? I'll describe what it is. With data minimization, I talked a little bit of an example previously where if personal data is shared on a website, you order a book, that personal data should only go to the delivery department. Now, if we extend this one step more, and we extend this and look at the use limitation, the use of that personal data, that means duplication of personal data, should be done in a way so that people, it comes into one of the principles of need to know principle, need to access and need to know, and these are actually defined in the GDPR. Need to know, you will recognize this from the ISO 27002 control framework. Those that are managing systems should only have access to what is needed for their job, the need to access. Need to know is when it comes to the controller or the individuals that have roles that should have access to the personal data, they should only know what is needed in order to do their job, nothing more. And that basically ties in nicely with the data minimization. Right, from your point of view, openness and transparency, it's the breach notification when you're looking at cloud and role as processor. You have to, if you have a data breach, you need to inform the controller as soon as possible. The controller has 72 hours to inform the supervisory authority, but you have to do it straight away, as soon as you are aware of this. Accountability is that you need to have the evidence in place, because the processor is liable also to penalties if they are not doing their job right. What this means, and this is something I was talking about even before I started at Privasee, my company, is that the processors will need to start thinking about limiting their liability from the controller. What if the controller is not caring, not doing their job right? You, as the processor, as the cloud provider, need to ensure that you're not liable. Now, I started talking about this a couple of years ago, and suddenly, in the last month, I've had 2 requests to do exactly this. Come into a cloud provider or a processor role, and to see how do we ensure that their liability is limited. Because you get into a lot about accountability boundaries, where the data is actually, the controller creates the data, collects the data, processes the data, but then it comes into your services. I don't have much time left, so you have to catch me afterwards if you want more on that. Yeah, now, what is really, really, really important in a role, your role as a processor, apart from having the contracts in place to limit your liability and to ensure the roles are defined, to ensure that you have the processes in place, that is not just policies and procedures, but also work instructions. You can follow same sort of principles that you're using for your ITIL environment, your incident management and that sort of thing. Is that you only do exactly what the controller tells you to do. If you do anything more than what you are requested to do, you will be considered to be a controller and liable for the same level of penalties as a controller. So what I normally say is you do what you're told to do. Don't be intelligent about anything to do with the processing of personal data. Even if you have a legal obligation to share personal data with legal authorities, you don't do it until you have consulted with the controller and they say it's okay. Okay, so whether you are a controller or processor, I recommend that you at least have some sort of semblance, because a lot of processes in cloud services, you don't have a lot of people, but you have a lot of services. But you should still have some sort of structure, and this is the structure that I work with, just to make sure that you have some sort of dashboards showing evidence of compliance. And that I talk about bottom-up is to making sure you do your risk assessments on high-risk assets. And you are actually, if we'll go back there, and also that you train your employees in Privasee, just a quick 20 minutes, so that they understand what their job is, which is to act as a processor, nothing more. The bottom up, that's basically projects where you're doing risk assessments or you're doing data discovery activities. That's basically what we work with. And what I say is that if you're going to start, when you start, get it right first time. And even though you're a processor, when you are serving your clients, don't forget, you're a controller. You employ people. So you are a controller. You, on your IT systems, you set up access for your clients to their data, which means you use their personal data to set up accounts, which could be their email address. That is personal data. So in that context, you have two roles. Your controller side you have for your operations to recruit people and to keep operations running. And the role that you have as controller in the fact you collect the data that you need for your clients to log in. And that's pretty easy to deal with. Just document it because it comes under legitimate interest, Article 6F in the GDPR. So you just need to have someone come in and say, look, that's what we do. And just write a quick document so you have evidence that you're doing that and you've done it right. And then what I sort of like to give a few tips on how to think when you're looking at how you are implementing GDPR when it comes to get it right. Individual-centric. When it comes to protecting personal data, security is needed for privacy, not the other way round. Security is a part of privacy. So it needs to be individual-centric. Risk assessments are done on individual-centric, not on system-centric. You need to have a data asset register, which is evidence of your data processing activities. Breach notification, I've already talked about that. We have our own privacy impact assessment, which I don't have time to go through. But in your cases, as a processor, it would be just down to step 3. I wouldn't need to go any further than that. Yeah, I like to see a privacy heat map, and I also talk about, I'm a bit short of time here. Basically, I also say, just taking this one here, I stole this from Philip Jonsson of the DPO of Sandvik, the Data Protection Officer. I say, see what you have already and reuse it. Don't reinvent the wheel. You already may have a breach notification process. How can you use it for personal data breach notification? How can you use your incident management process? Do you have a crisis management process? Do you have an InfoSec program and you can use the same format for your privacy program, etc.? And then there is actually, you can start thinking about measuring your maturity using some sort of maturity model. And that's it, questions.
Thank you. We'll give you an applause. We have Emmy here at the microphone. We have time for one question.
Do you see a big difference between HIPAA and GDPR?
Between HIPAA and the GDPR? Yeah, well, HIPAA is, because the US has a patchwork approach to their regulation, and HIPAA is for the healthcare. So what you need to do, when I showed you the ISO 29100, you know, the privacy framework, that's basically what we work with. We've mapped the GDPR into that. What we would also do is take any specific healthcare regulations that may be stricter than GDPR, and we would map them in. And if they are already there, then we don't use it because they're already covered, you know, like a sort of a shield approach. But yeah, you may have to have extra requirements, but you add to it. GDPR is strong, but you may still have other requirements. I talked about clinical trials. It could be HIPAA in the US or whatever. No. That's where you can take the basis and work from that. I don't know HIPAA that well, but I know they have some things that's specific for the US that you can't ignore. Okay.
I have a question also. You mentioned the word processor.
Yeah.
Is the CIO the most suited people to be the processor, or do you have any thoughts on who should be the processor in the organization?
The processor, so you have the roles that are important in GDPR. The controller, of course, is the legal entity that is collecting and processing personal data. And the processor would be, for example, who they are the legal entity that is being requested to process their personal data. So they may use a cloud service, for example. You know, an HR department may use a subcontractor to do the payroll.
Yeah.
So that is the processor. Now, what you were referring to is the data protection officer, the DPO.
Yeah.
And, you know, there is a lot of organizations, when I say about doing it right, is actually saying, where should you have your privacy? And do you need to have a DPO? And yes, you need to have a DPO dependent upon the size of your organization. And also dependent upon the sensitivity or the amount of data. Now, who should be that role? It really needs to be somebody that understands the legal stuff, somebody that is very experienced. You can't put a junior person there. Somebody like, if they've got a CISO level at the moment and they actually have some legal understanding, then you could put them in there. But you need to be extremely careful. There's actually there is whole day workshops, week workshops just on DPO thing.
Okay, thank you. But will you be here for lunch? Will you be staying here?
Yeah, I can stay here. I can stay here until about 1 o'clock.
So,
yeah.
Thank you very much.